How are we all doing today? We're continuing our discussions on custody and divorce, and today our topic is types of custody arrangements and settlement options. So I won't say this is going to be a lot of legalese, but it's going to be a bit technical, but it's important for you to understand all the distinctions here and make sure you understand really how everything works. So bear with me. It's good stuff, but it gets a little detailed. Anyway, but before I get into the legal distinctions of child custody, I think it's important to put everything into perspective. And as I've mentioned previously, you should focus on having a parenting plan that works for both of the parents and is in the best interest of your children. The actual timeshare and the legal title are less important. I'll say that again. The actual timeshare and the legal title are less important. Our objective here is to do what's best for the kids. We always want to think in terms of what's in their best interest. And sometimes you may have to come to the realization that if you work long hours during the week, your children being with you during the week, maybe that's not in their best interest. Anyway, if you start with what's best for the kids and what works for both parents, then you work backwards to see how the timeshare comes out. That's the correct way to do it. If you do this, it's ultimately going to work out better for everyone. Now, if you get too caught up in the legal terminology such as primary custodial parent, primary legal parent, then you're going to start down the wrong path, and it's going to get really expensive. Your legal bills are going to mount from trying to put a square peg in a round hole. Now, please keep this in mind as you think about the significance of each of these distinctions. What's really most important to you? Is it the money, the emotions, your ego, or your children's future? Okay, what is child custody? Child custody is a legal term used to describe the living arrangements and the decision-making authority that a parent has over a child following a divorce or separation. Child custody agreements outline parents' rights to make decisions on behalf of their children. The type of custody arrangement that's ordered by a family court will determine where the child lives, what type of visitation schedule might be used, who will be responsible for making major decisions on the child's behalf, and how much the child support is paid by the non-custodial parent. Now, two different types of child custody are legal custody and physical custody. Legal custody grants a person the authority to make major decisions on the child's behalf. The parent with legal custody is the one who makes the decisions about school, medical care, religion, and other child rearing. In other words, all the long-term decisions. Physical custody determines where and with whom the child is going to live. It refers to who has the right and the responsibility for the day-to-day care of the child. Typically, the child lives with the parent who has physical custody, and that parent is called the custodial parent, or the primary custodial parent. The other parent, called the non-custodial parent, typically will have a visitation schedule and be required to pay child support to the custodial parent. Once again, don't get too caught up in this, because once you get into it, it doesn't make that big of a difference. So don't let your ego enter into this. Legal custody and physical custody together make up child custody, but it's also important to realize that it's possible and common for parents to share or not share both legal and physical custody, or share one and not the other. Now, this leads to 4 different custody classifications. The first is sole physical custody. This is a child custody arrangement where the child physically resides in one home. And as opposed to joint custody, where the child has 2 homes, sole custody does not have the child move from one home to another via the terms of the custody agreement. Now, instead, the non-custodial parent will visit with the child. Now, this may include sleepovers at the primary custodial parent's home. And while there are some benefits to sole physical custody, like a more stable routine for the child, the drawback is that the non-custodial parent feels more like a visitor than an actual parent. Now, this has a tendency to increase conflict, not to mention confuse the child as to what each parent says they should have in the child's life. Now, because parenting involves much more than activities during a visit, sole physical custody robs the non-custodial parent of their chance to really parent the child, as would be the case with a joint custody arrangement or a co-parenting lifestyle. She wants full custody. Anyway, next category, joint physical custody. Joint physical custody, sometimes called shared physical custody or joint custody, is a type of custody arrangement that grants the physical component of child custody to both parents after divorce or separation. Now, when joint physical custody is awarded, both parents are considered to be the custodial parents. Now, this means that neither parent is considered the non-custodial parent. Joint physical custody is the preferred option for cooperative parents, and a lot of courts are moving towards this. All right, wait a second. Sorry about that, kitty. Okay. But it's only one of many options that can work for divorced parents with a child. The term joint physical custody is derived from two different terms, joint custody and physical custody. Once again, physical custody refers to where the child resides. But when joint physical custody is awarded, both parents share a significant amount of time with the child. Physical custody does not imply which parent has decision-making authority for the major decisions. That's legal custody. So legal custody, by contrast, refers to which parent or guardian has responsibility for making the important decisions. So physical custody, where the child is; legal custody, who makes the decisions. It's not that complicated. Okay. If parents have joint legal custody, they may and should consult with one another on big decisions, such as religion, schooling, medical care, and things like that nature. Now, parents can have joint legal custody if they don't have joint physical custody. Often divorced parents don't have physical custody because one lives too far away, yet they share joint legal custody. And even though one parent is the non-custodial parent and has less parenting time, significant decisions regarding the children are made together between both parents. Neither parent in a joint legal custody arrangement is able to make long-term decisions unilaterally. Now, although rare, divorced parents can have joint physical custody if they don't have joint legal custody. Now, this is an arrangement that occurs where both parents share physical custody, but one parent has all the rights for full legal custody, so they make all the long-term decisions for the children. Now, this arrangement may allow for the parents to avoid conflict, since it's structured around one parent being responsible for significant decisions, rather than both having to reach an agreement. Because physical custody refers to where the child is being cared for, then the parent with physical custody is still able to make decisions about the child when they have them in their care. Now, this brings up an important point about what decisions constitute major decisions versus minor day-to-day decisions that anyone in taking care of a child would have. Now, the simplest way to explain the type of decisions that are made via made via physical custody versus legal custody is to apply an idea invented called the babysitter test. Now, essentially, think of the decisions a babysitter might be expected to make as being the types of decisions that the physical custody component of the child custody allows. Babysitters would make decisions about daily issues such as what to make for dinner, what time the children should go to bed, whether it's too cold to play outside. Physical custody allows the same type of decisions, but legal custody is different. We're talking about major decisions, like what religion should the child be brought up in. That wouldn't be made by a babysitter. If a decision would be inappropriate for a babysitter to make, it's likely a legal custody decision. If a decision is a legal custody decision and parents have joint legal custody, then both parents need to be aware of the issues and work out the solution together. Now, physical custody decisions, conversely, do not have to be discussed. It would be impractical for the parent with physical custody at the time of the call to call the other parent and ask how to handle every decision. So joint physical custody has its pros and cons, but the following are the advantages of both parents having shared physical custody. A child can experience a childhood being raised and influenced with each parent. Children usually want a relationship with both parents, and joint physical custody arrangements can help maintain the connection that children have with both parents. Next is, each parent is equal in the eyes of the court. Neither parent feels relegated to a lesser parenting role than the other. Next, the time each parent has with the children is approximately equal. However, it's important to understand that joint physical custody does not automatically mean that both parents have exactly equal time with the children. Instead, both parents have significant time with the children, which can be arranged when the child custody schedule is created. Parents are likely to share the expenses of raising a child in a more equitable manner. Child support may be significantly reduced or eliminated, since both parents might have the children almost the same amount of time. Visitation does not exist with joint physical custody relationships, so no parent is referred to as a visitor or relegated to the role of visiting parent. Now, the disadvantages of joint physical custody are, because there'll be two homes, the children will need to adapt to two completely different environments. Frequent custody exchanges can create stressful and disruptive situations for the children, especially if there's a high level of conflict between the parents. If the parents don't live very close to one another, then the child's ability to commit to extracurricular activities, such as sports or social clubs, can be diminished. Joint physical custody is much easier in low-conflict relationships, where the parents can co-parent. Kitty wants to be in the middle of this. Sorry. Okay. Now, the following are important factors to consider when developing a joint physical custody schedule. 1. Distance between the other parent. The distance to the child's school. The work schedule of both you and the other parent. Other obligations. How to handle unexpected matters when they come up. Who'll get the kids when school's canceled or the child is sick. Activities or clubs the children participate in regularly. Vacations. Now, parents can choose from a variety of shared custody schedules, from 1 week on to 1 week off, to having children half the week during the week. Now, note that it may be advantageous to give the schedule a trial period before modifying the divorce decree. So this will help each parent identify issues before committing to it in writing, because sometimes what might seem like it makes sense in theory doesn't really make sense in practice. So this brings us to our third category, sole legal custody. Pretty straightforward. Sole legal custody is a court order that grants legal authority to one parent and one parent only to make the big decisions, the long-term decisions on the child's behalf. Decisions that fall under the domain of legal custody include educational decisions, religious upbringing, and healthcare decisions. So legal custody, or sole legal custody, is different from sole physical custody. A parent with sole physical custody is referred to as the custodial parent. They have the legal authority to decide where the child lives, though some restrictions, of course, may apply, depending on where you decide to live, the state you live in, whether there's a relocation clause. The custodial parent is the one who primarily cares for the child and makes arrangements to make sure they have adequate and stable environment. Legal custody does not deal with where the child lives, but rather how the child lives. It's possible and fairly common for one parent to have sole physical custody, but joint legal custody. Now, the primary custodial parent applies to the physical custody component of child custody. Being the custodial parent does not imply anything about how legal custody is applied. Generally, if both parents want legal custody and can demonstrate the ability to cooperate, then they're going to get joint legal custody. This means they need to find ways to work together in order to compromise on major decisions that fall under the domain of legal custody. This can be easy if the divorced or separated parents have similar beliefs or ideas, but if the parents have different opinions on how the child should be raised, then conflict can result if the parents are not able to communicate and compromise. So let me say this now. In general, now, in 2019, going on 2020, most states, most courts want to give joint legal and joint physical custody. This has not always been the case, and some states like New York are still, say, behind the times on this, but most states are moving to this. If you both want to be involved, and there's nothing wrong with either of you, the new norm is really joint physical and joint legal. Now, if one of you has a substance abuse problem, a sex problem, you just work too many hours, then that's a different story. Or if there's a super high level of conflict between the two of you, that's a problem too. But we have to understand that the courts have really changed their view on this. So nowadays, most parents, once again, if you're both interested and there's nothing majorly wrong with the two of you and there's no major conflict, the courts really want to give both joint legal and joint physical custody. Okay, back to our trip. Now, the disadvantages of pursuing sole legal custody is that one person's decision is typically not as good as two. Even with the sound judgment can benefit from hearing another person's opinion. And when it comes to children, two people that are likely to love and care about them more than anyone, no one's going to care more than their parents. Now, having two parents, both who, in theory, want to do the best thing for the children, is typically going to help arrive at the best decisions for the child. So even if she's a great mom, your opinion's actually going to help, and vice versa. It's always better to have two heads, two pairs of eyes, two pairs of ears making these decisions. Okay. Now, anything that might result in conflict between the parents that can lead to litigation and threatening to take away legal custody from one parent can do just that. So if the other parent wishes to remain involved in the children's decisions, they're likely to fight for joint legal custody. Now, assuming a person decides to litigate for sole legal custody, a family court may order, if there's a history of neglect, abuse, or some other activity that makes one parent unfit. Now, assuming that the other parent is not unfit, it depends on the judge, it depends on the jurisdiction. And if the jurisdiction has a history of awarding joint legal custody, then the court is likely to order joint legal custody. Assuming joint legal custody is ordered, it's imperative that both parents work to create a detailed parenting plan that they can adhere to, so future arguments are reduced or prevented regarding legal custody decisions. A well-thought-out parenting plan can alleviate a potentially contentious issues for the future. And we're going to do this later. We'll talk in another section of parenting plans, but a custody agreement is basically bare bones, and it's just going to outline some of the major decisions and the actual custody schedule, where a parenting plan is going to be much more detailed, and it's going to have contingencies in there, and it's going to talk about a lot more. Courts require a custody agreement. They don't require a parenting plan. If you want custody, you should have a parenting plan, and not just for the purpose of getting more custody, but for actually thinking through your child's future, what is best for them. And it's also going to help you clarify in your mind what's important to you, what decisions do you want to be involved in, what matters. So, always better to have a parenting plan. We'll talk more about that later on, but courts don't actually require it. Okay. So, if you have joint legal custody, you're required to consult and discuss major decisions with the other parent before implementing them. If you fail to do so, you do risk being taken back to court and found in contempt. Now, in such a situation, it's possible that a family court could change the court order to give sole legal custody to the other parent. So, once you have this in place, it's important to actually stick to it or everybody goes back to court. And again, this is why it's so important to understand the differences between physical custody and legal custody. Just because a person is the primary custodial parent doesn't mean they're free to make long-term decisions or child-related decisions unilaterally. Now this brings us to our fourth category, joint legal custody. Joint custody is the legal term used to describe both parents sharing the responsibility of making long-term decisions for the children after divorce or separation. Joint legal custody means that major decisions about the child's life must be discussed and worked out by both parents. Once again, joint legal, both parents decide. One parent does not have the ability to decide for the other parent. Major decisions include education, health, dental, emergency care, religious practices, extracurricular activities, child's name, things like that. The term joint legal custody, once again, has two components, joint custody and legal custody. Legal custody is the component that gives the parents the right to make decisions about the child's upbringing. When there's joint legal, decision-making authority is shared equally between the two parents, even if there's not a joint physical custody agreement. So one parent, as long as it's joint legal, both parents are equal. Joint physical, you're not necessarily one, it could be a 65-35 timeshare, so it's not exactly equal. But joint legal, neither parent is more important than the other, even if one of them has the bulk of the time with the physical custody. So keep that in mind. Now, having joint legal custody can put a lot of pressure on the primary custodial parent, as they're obligated to consult and collaborate with the non-custodial parent about all the big decisions. So, if the primary custodial parent wants the children to go to church, but the non-custodial parent is an atheist, they have to work that out or figure out a way to collaborate on this issue. And this, of course, can create major conflict if the parents refuse to cooperate and compromise. Now, the benefits of joint custody are that the child benefits from co-parenting. As we talked about earlier, two people making decisions is better than one. While not as ideal as the traditional nuclear family, there are significant advantages to joint legal custody when the parents are able to co-parent peacefully. Co-parenting requires both parents to communicate about the children after divorce. This tends to be more beneficial to the children and their relationship with both parents as the children grow in adulthood. And it's always better to have two perspectives. Having two parents to discuss and compromise on legal custody questions typically makes the ultimate decision better than if just one parent acted unilaterally. The disadvantages of joint legal are that because joint legal requires both parents to collaborate around significant issues regarding their child's welfare, disagreements can result in conflict. If parents become too unwavering on certain decisions, they could find themselves in a situation where it's impossible to make a good decision or everybody's going back to court. So it's great if the two of you can compromise. If the two of you are going to fight about everything, joint legal can be a problem. So keep that in mind. Now, there's something called parallel parenting, which is an arrangement in which divorced parents are able to co-parent by means of disengaging from each other or having limited direct contact in situations where they've demonstrated that they're just unable to communicate with each other in a respectful manner. This often happens when the divorce is fresh. Parallel parenting is necessary if the parents are just unable to resolve their conflict, if the level of negative emotion is too high between them and they just can't agree on anything. Now, here's where a detailed parenting plan is especially helpful in high conflict situations where there's joint legal custody. This way, it's like you always go back to the plan. All right, this is your call, this is your call, this is what we said. If we can't reach an agreement, this is what we do. So a good, well-crafted parenting plan can act like a referee when parents disagree. Now, when parents can agree, or one parent feels that the other parent violated the terms of the parenting plan or the custody agreement, then one parent can file a complaint and take the other parent back to court. However, depending on the situation, this may have negative results for both of you, both legally and financially. It's advisable to try mediation before going to court, because oftentimes the judge may simply force the parents to mediate before hearing a complaint regarding custody anyway. In general, a judge's mandate is to get you through the divorce and out of the system. So let me be clear about this. Coming back after everything is settled rarely produces a good result. It demonstrates that you have difficulty cooperating. So in general, you want to avoid going back to court for such issues unless they're critically important or the circumstances have changed significantly. So if you're going to complain about every little thing the other parent does and you want to bring them back to the court, it's not going to end well for either one of you. So once again, you need to have a good parenting plan for this reason, to act as a referee, because if the court has to act as a referee after everything's final, it's going to get ugly. Now, when divorced parents agree to approach decisions by, considering what's in the child's best interest, it can help reduce conflict. I mean, if you can just come to the realization that maybe you're not 100% sure of everything and that maybe you do need collaboration with your ex, you're going to do a lot better. Once again, if we can get the egos out of this and just trying to compromise for the sake of your children, if that's your attitude, if that's your mantra, if that's the way you do things, it's going to be much better for your children. Now, the following are common examples of disagreement that affect parents with joint legal custody. Where does the child go to school? What religion will the child be raised in? How will the child's health condition be dealt with? What activities is the child expected to participate in? And here are a couple of tips for dealing with these decisions. It's always good to seek out support from a neutral third party, maybe a family therapist or a professional mediator. Have both parents write down a list of pros and cons about the applicable decision. Brainstorm. And note, when brainstorming, ideas are not to be rejected. Identify any options that allow for compromise. Consider if both viewpoints can be implemented. For example, maybe a child can be exposed to two different religions. Now, what happens when the parent with primary physical custody moves to a different place and the child where there's joint legal custody? This is complicated, and this is another reason to have a good parenting plan, because there should always be a moving away clause. Custody arrangement is granted, okay? Usually when a primary custodial parent wants to move with the child to a different place, they're going to file a petition for a move. The other parent usually is then notified by the court, and they're going to make a ruling in the best interest of the child. So, even if you're the primary custodial parent, and you want to move to a different place, and you have sole legal custody, the court can still look at it and say, you know what? This is not in the best interest of the child. We don't think you should do this. So, my point is, you need to be very, very careful when it comes to any of the move away stuff, because a lot of times parents do it just to screw with the other parent. So I recommend A, being very precise and clear on the language in your parenting plan on this, and B, if at all possible, don't move away, because you know what? It's rarely in the child's best interest to uproot them. So you're going to have a really compelling reason, even if you are the primary custodial parent, even if you have sole legal custody, you're still going to want to think through this. And in general, especially when the children are young, I recommend avoiding this at all possible cost. Okay, now when distance becomes a factor, it's going to affect certain aspects of legal custody. So you may not be able to enroll your child in sports or extracurricular activities because it would interfere with visitation. So how does a court determine the type of child custody arrangement after a divorce? Typically, dissolution of a marriage involves negotiations and/or disputes over how child custody should be allotted. Child custody is often decided by a family court, once again according to the best interest of the children doctrine or best interest standard. This means that the judge will attempt to determine which type of child custody arrangement would be most beneficial for the children involved in child custody case. Now, a few factors that affect the court's child custody order are the type of work schedules that the parents have, where the parents live and where the child has lived, substance abuse history for the parents, child abuse history for the parents, is there any history of abandonment, the relationship that the parents have with the child. There are many other factors that the court's likely to look at as it evaluates the child custody case, but it's going to do so within the framework of the best interests of the child doctrine here in the United States. So, what issues should parents consider before signing a child custody agreement? Before signing an agreement, both parents should take time to seriously consider the ramifications of the documents which they're going to be signing, even if they're only temporary. The documents will likely affect the quality of life for the children and both parents, as well as child support payments until the children reach adulthood. Many parents make the critical mistake of assuming that a temporary child custody agreement is not important. Sadly, this results in many divorced parents getting into a disagreement that later requires additional litigation. So let me make this clear here. Unless the child's very young, when you do a temporary agreement, it's most likely going to become a permanent agreement. So you want to be careful before putting that together. Now, if you're freshly separated, you need a temporary agreement, and the judge will understand that. But in general, your long-term agreement is usually going to look like your temporary agreement. So be careful about putting that together. Don't just say, okay, we'll get to it later. Because if one parent gets 75% of the custody temporarily, guess what? Chances are they're going to maintain that or a percentage like that over time. Okay, so joint custody is, of course, something to be seriously considered. It can lead to better co-parenting that keeps both parents involved in the child's life. It's healthier for the child, as long as there's not a high level of conflict. And while one parent might not initially consider the idea of joint custody as the best option, it does offer some protection against the other parent relocating out of state. Now note that joint physical custody does not necessarily mean or in any way imply that each parent has 50-50 custody of the child. It merely implies that neither parent is the non-custodial parent. Even in the case of sole custody, a relocation clause should be considered as a way to prevent one parent from moving without the consent of the other. So the move away is a huge issue, so make sure you think through it, make sure it's in there. Okay, here's a new subject, maybe you never heard of, collaborative divorce. What is collaborative divorce? The California Collaborative Association uses a method known as collaborative divorce for resolving divorce and custody where the divorcing parents work with a team of professionals that craft their own agreement. So you work with a neutral team of experts. It could be a financial advisor, it could be a therapist, it could be a lawyer. The parents work together in a respectful way, keeping in mind the importance of protecting their children and other people involved from conflict. Decisions are made by participants without the involvement of a judge. So this is a relatively new thing, and it's fairly progressive, but it makes a ton of sense, especially when there's significant assets involved. And both parents want to do what's best, but they know they can't do it on their own. So you're employing a team of experts to work with. Now, there are some intricate rules that apply to it. So by being committed to the collaborative process, which is an approach for solving problems by mutually agreeing to the solution, parents and professionals work together respectfully in good faith to gather information needed to reach an agreement. The goal is a win-win situation for all participants. Now, both parents and the collaborative professionals agree from the onset that the case will be settled, not contested. Very important here. If the case can't be settled, the attorneys and the other professionals must withdraw, and the attorneys will assist the participants in finding new attorneys to help them settle the case through the traditional court system. So let me be clear about this. If you start out in the collaborative process and you decide we just can't do this, you can't keep the same lawyer, you can't work with any of the same professionals in the collaborative process. So you're going to be starting all over again. It's going to get very expensive, but more importantly, you can't keep the lawyers. So Typically, parents and professionals meet together to plan for information gathering. They make interim arrangements, they discuss issues, and a team is assembled based on the participants' needs, and it can include attorneys, custody coaches, child specialists, financial experts, and any other professional that may be needed. Information gathered will be shared with other clients. Everything is shared equally, and the team members, in order to clarify each participant's interest and to generate ideas for possible solutions. So this is not us versus them. This is, we're all going to work this out together, and we have all these professionals with us that are going to help. All communications made during collaborative process remain confidential and cannot be used if the case later goes to court. So, like I said, if you start out collaborative and then you decide you're going to go to court, everything you did in the collaborative is non-admissible. Not the evidence, not the lawyers, not the information. You literally have to start all over. So a settlement which does meet the approval of all clients can then be fashioned. And this method of handling conflict is designed to minimize hostility. Collaborative approach is becoming more popular, similar cousins mediation, but in order for it to work, both parties have to be committed to resolving the dispute. But if successful, both parties are going to save a lot of time and money. But once again, you really have to want to compromise and you want to finish this. This is the best way to do it if you can do that. Once again, if there's not a high level of conflict. If there is, it's probably not going to work. Okay, let's turn to mediation now, the cousin. Mediation gives parents trying to decide child custody a chance to resolve disagreements about a parenting plan for their children. In mediation, the parents have the help of an expert mediator in resolving these disagreements. If the parents are able to work out an agreement, the mediator helps the parents write a parenting plan, and then it becomes a custody visitation order. If it's signed by the judge, or once it's signed by the judge. Most judges require the parents to go to mediation to see if the parents can reach an agreement without the intervention of the court. The goals of mediation are to help you make a parenting plan that's in the best interest for your children, help you make a parenting plan that lets your children spend time with both parents, and help you learn ways to deal with anger and resentment. It's good to use mediation early. It's a tool, it's not a concession. The earlier you settle, the more money you can save later on that can go to your children. If mediation does not work, you can always litigate later, but it's always better to at least give mediation a fair chance. Mediation is confidential. When you come out of the mediation room, either you have an agreement or you don't, but you can't present anything that went on in there to the court. So, yeah, it's basically yes or no. The mediator can only inform the court that an agreement has been reached or no agreement has been reached. Now, it's possible for the mediator to make recommendations with regard to custody, evaluation, restraining order, or the court appoints an attorney for the child. So they have some power, the mediator, but in general, they just want you to come to an agreement and they'll draft it for you. They'll give you advice on it and it goes to the court. If you don't agree, sorry, Your Honor, we couldn't agree. That's it. That's all the judge gets. Temporary custody orders. Temporary orders are meant to be just that, temporary. However, as I said earlier, one of the biggest mistakes a parent can make in family court is agree to a temporary order, thinking he can change it easily later on. Because temporary custody orders are rarely temporary. They usually establish a precedent that adds the extra obstacle of changing the child's routine later on or in future custody proceedings. Once again, they don't want to upset the boat. They want to keep the child's life steady and consistent. So you don't want to agree to this now, and in 6 months we're going to change it. That's what they're trying to avoid. So you want to think about this before entering into a temporary agreement that you're just saying, oh, whatever, because it will matter later on. Oftentimes, these orders become permanent and they influence future custody determinations. So temporary custody orders are commonly implemented at the beginning of a divorce proceeding or until a full custody hearing can take place, and in some cases, until a custody evaluation is completed. A As time passes, the temporary arrangement becomes the status quo. So if at all possible, obtain a favorable temporary custody agreement from the onset. But, I mean, it happens, you have to do it usually as soon as you're separated, you have to put something in place. Just don't give away the farm, because it's going to be much tough to get it back later on. Stipulated orders. When parents choose to mutually agree to modify their parenting schedule without the use of the court, that's known as a stipulated order. It's best to have their agreement filed with the court in the form of a stipulated order so the agreement can be enforced. Stipulated orders generally are signed by both parents and the judge. Furthermore, they include a list of parental agreements, usually with regard to custody and visitation. So it could be an updated custody agreement, updated parenting plan, something of that nature. A couple of other orders you should be aware of. Final judicial orders. These are orders or judgments generally result in a decision made by a judge. In terms of custody orders, a final judicial order is referred to as a judgment or permanent custody order. So you don't want to usually go there. Once again, you don't want the court making decisions for you, so just be aware that those exist. For those of you in high conflict or with a partner or ex that's doing weird stuff, there's something called ex parte orders. And ex parte orders are basically emergency orders based on the request of one parent. Usually, a parent would make an ex parte request if it appears to the court that the child's life or safety is somehow in jeopardy. So you only want to do this when something very significant and potentially dangerous is going on. In some cases, an ex parte order can be granted without a hearing from the other side. A hearing is usually set within a day or two, so both parties may be present. Judges typically prefer to avoid ex parte hearings because it's not uncommon for the other side to file an ex parte response shortly after presenting their side of the story. Also, realistically, there are not too many times when the child's life is in danger, or they feel that they're being threatened, and that the court can do something about it in 1 or 2 days. So a lot of people use this when they're really angry. Oh, they deprived me of my custodial time. That's not what ex parte orders are for. People try to use it. Sometimes it works, sometimes it doesn't. Ex parte is when you really feel the child's life is in danger and you need to get to the court quickly. You just call them up, say, I'm going ex parte. You do have to notify the other side, but if they can't make it, that's life. Okay, one final order I want to mention today is kick-out orders. Kick-out orders are often initiated during a divorce to remove one party from the family residence. Typically, these judges hold the position that if one party objects to living with the other, they shouldn't be forced to live in the same residence against their will, especially if children are involved. So, as always, if you have a high level of conflict, if there's any kind of physical altercation, if somebody feels that they're unsafe, there might be a kick-out order. Unfortunately, this is a tactic that a lot of women use. They'll say that their lives were threatened. I mean, it can be used against guys too, but it's more common the other way. I don't feel safe around him. They go for a kick-out order, and it does tilt the scales of custody. So you do have to be careful with that. A lot of times at the beginning, people are going to do crazy, nasty things, and it can hurt you in court. So don't give the other party a reason to get a kick-out order. You want to maintain a level playing field. If you know you're going to be divorced, you know you're going to separate, try to work things out, try to stay calm, try to think about what's in the best interest of the children. I mean, this is the best advice I can give you. It will save you thousands, hundreds of thousands of dollars. If you want to fight to the death, you're going to be sorry. Trust me, it's going to cost you. It's going to cost you financially, it's going to cost you in terms of your sanity, and it's going to cost you in terms of your children's mental health. Anyway, that's it for our section on court orders and distinctions and legal distinctions. So I look forward to speaking to you next time. I don't know what our topic is next time, but I'll let you know. This is Joe Pastore with My Custody Coach and Platinum Method Coaching. Until then, make it a great day.